Thank you very much for joining us for this panel discussion on the intersection of trade and public health. We have slightly smaller crowds than we expected, but we are very grateful that you are here with us. And I think that may give us a good opportunity to have an interactive discussion after the presentations. It is a very important topic, and I think there's a lot to be said about it. I think I actually met everyone in the room, so I don't have to introduce myself, but just for anyone online, my name is Joanna Redelbach, and I will be the moderator of this panel. I am joined by three distinguished speakers. We have to my right, Yoshimichi Ishikawa, who is a lecturer at the University of Shizuoka in Japan, and who also worked in the past in the Ministry of Foreign Affairs of Japan, dealing with WTO disputes. We then have Francisco Fernández, I hope I pronounced your name correctly, who is a legal affairs officer at the WTO in Geneva in the IP division. And last, but certainly not least, we have Parwani, who is a researcher and a PhD candidate in the University of Amsterdam. Now, the topic of the intersection of trade and public health is a very broad one and not a new one. But now in the experience of the COVID pandemic has prompted a new reflection for many of us on how the existing trade rules can assist with facilitating access to medicines and what can be done in terms of trade measures to avoid supply chain disruptions, especially in situations of health emergencies. And this also links with a broader question on how trade-related measures operate within the WTO system, within the existing rules. What is the regulatory space that is available to WTO members, and how to balance health objectives against the need to avoid protectionism and adopting measures which unnecessarily restrict trade. All these issues will be addressed today by our panelists. And I think we have a very nice mix of specific topics that will be covered, starting with health-related labeling and then moving to the issue of local production of medicines and vaccines. In terms of structure, we will start with short presentations by each of the panelists, followed by hopefully interactive Q&A session and panel discussion. So we very much welcome any questions from the audience. So feel free to already start thinking about your comments and questions to the panelists. I think I will stop here and I will pass the floor to Yoshi for his presentation. Thank you.
Hi, good afternoon, everyone. Joanna, thank you for your kind introduction, and the many thanks to the organizers for this wonderful conference. So my name is Yoshimichi Ishikawa. Please just call me Yoshi. I'm from the University of Shizuoka in Japan. I am very grateful for the chance to speak today. Let me start by just a second. I have to count the time. Yes, let me start by talking about alcohol and its health impacts. Most of us agree that drinking too much alcohol is bad for health. However, when it comes to moderate drinking, or many people think that having a little bit of alcohol might actually be good for health. But the science says otherwise. In recent years, the WHO and some health authorities have said that there is no safe level for drinking alcohol, so which means that even moderate drinking can be harmful. Nevertheless, many studies show that a lot of people actually don't know the health risk of alcohol, especially the cancer risk. So therefore, these days, the cancer warnings on alcohol are getting more attention these days. So these are the warning messages that placed on the alcohol bottles to inform consumers about the cancer risk. So please take a look at the slide. So this is the health warning labels on alcohol, which will be introduced in Ireland from next May. In Ireland, it will be mandatory to place this entire label on the alcohol products which are sold within the country. So if you look closer, there's one warning says there's a direct link between the alcohol and fatal cancers. So this is the cancer warning label that I am focusing on in this presentation. So what does this mean for international trade? The purpose of the health warnings on alcohol is, of course, to discourage people from drinking alcohol, including imports. It means that such a measure can easily or naturally affect the import of alcohol. That is why when Ireland notified its measure to the WTO, 9 members raised concern at the TBT committee, arguing that there should be other less trade alternatives for the Ireland to reduce alcohol consumption, such as education campaign. Okay, so the key question here is the consistency of the health warnings on alcohol with the WTO law or trade law. However, this question seems to be losing its importance in recent years. Let me show this why with using 2 examples. The first, in 2010, Thailand planned to introduce graphic health warnings on alcohol. However, they faced a strong objection from the WTO members at 7 TBT committees over 2.5 years. Eventually, they dropped its plan. By contrast, for Ireland, yes, WTO members also raised concern at the TBT committee, but this time only 3 times. They stopped raising the concerns at the TBT committee, even though Ireland still continues to maintain the measure. Moreover, no WTO dispute has been filed against Ireland. So in short, for Thailand, the members kept up pressure until the plan was dropped. But on the other hand, for Ireland, the members easily or quickly backed off and took no further action. Then, of course, the question is why WTO members took such a different position on similar measures on a similar issue? That is the first question. So second, this time let's focus on the WHO. In around 2010, in several documents, the WHO used to describe trade law as an obstacle for countries to implement health measures. However, there was a shift. So starting around 2020, all of a sudden, the WHO strongly recommended the health warnings on alcohol, but this time without referring to any concerns of the WTO compatibility. The point is that, so the WHO's view on trade and health changed a lot between 2010 and 2020. Of course, the question is why WHO changed its position like this during this period of time. Okay. In my view, these contrasts were mainly caused by the WTO panel decision in Australia plain packaging case. But how? But why? So next, let's take a closer look at this landmark dispute. In this dispute, the Australia passed a law requiring all tobacco products to be sold in plain packages, without any logos or without any brand designs. So 4 WTO members, actually 5, but 4 WTO members challenged Australia's measures, claiming that there should be other less restrictive ways for Australia to reduce smoking, such as education campaign, instead of plain packaging. However, the panel concluded that none of the proposed alternatives can reduce smoking as effectively as the plain packaging. And in reaching this conclusion, here's the key point. Panel additionally referred to what could be described as a paradox. So what is a paradox here? As everyone knows, the GATT or TBT agreement, if a complaining member challenges the necessity of the measure, it is supposed to find out the alternative measures that are less trade restrictive, but can still achieve the objective to the same extent. However, this logic doesn't work that easily when it comes to measures to reduce harmful consumption, such as alcohol or tobacco. Why? Let me explain. If the alternative measure is less trade restrictive, it means that under this measure, more imported tobacco or more imported alcohol remain accessible to the consumers within the market. So which means that less trade restrictive measure is also less effective reducing the harmful consumption. So that is why it is virtually impossible for the complaining member to demonstrate or propose the alternative measures. First, that are less trade restrictive, at the same time, equally effective. That is called the paradox that I describe in my paper. Okay. So this is the paradox of the paradox. So let me conclude. We should have 4 minutes. So let me conclude. So because of this panel, because of this paradox, the panel, importantly, the panel in this dispute accepted this paradox and effectively granted the significant margin of the policy discretion to the regulating countries or regulating members. So let me conclude. So because of this panel ruling, so the WTO members, for example, for the Ireland cancer warnings, WTO members didn't have to keep raising concerns at the TBT committee, or they didn't bring a dispute to the WTO. Why? Knowing that it would be almost impossible for the members to successfully challenge the measure against Ireland because of this panel decision, which accepted, as I said, this paradox. The same here for the WHO, likewise, that they no longer need to refer to the concerns of the WTO compatibility anymore. This is because, as I already said, the panel recognized the very wide policy space for such measures. So these two examples, in my view, illustrate that WTO panel decision, in this case, Australia plain packaging case, this panel decision has played a role in de facto rule making in global health, affecting not only the WTO members, but also other international organizations, in this case, WHO, far beyond trade system. So nevertheless, it is important to remember that this panel's de facto rule-making function depends on the proper functioning of the WTO dispute settlement. So from that point of view, it is still the restoration or the recovery of the dispute settlement system is still necessary. So this is the end of my presentation, and thank you very much for your attention, and I look forward to discussing all topics with all of you. Thank you.
Thank you very much. I suggest that we move to the next presentation and then we have discussion and questions. So Francisco, if you can go ahead. Thank you.
Okay. Excellent. So they have already put my slides. So good afternoon. Thank you, well, first of all, to the organizers, to Joanna for moderating this session, and to SIEL Conference and the Asian Center for WTO and International Health Law and Policy for gathering us and organizing this event. So I'm here to present a topic that is called How Local Can Be Global Trade, the case of local production of medicines. So first, allow me to say that everything that I'm going to say from now on are my views that are strictly personal and do not reflect the official position of the WTO Secretariat nor its members. So I'm here in a personal capacity. So with that, allow me to start a little bit sharing some reflections on the paper. And the paper basically started with this notion on how local can be trade. I started with a speech of D.D.G. Lamy, who he, in a speech, said, in today's world, there's no words made in France or in Korea, but they are made, goods made in the world. Of course, the COVID-19 pandemic came along and shattered much of that notion. Especially because, I mean, the whole logic of trade, and Yoshi has already mentioned it, up to this point, and the WTO really embody that notion, is the idea of liberalization, is the idea that trade has to flow freely, and therefore in health-related goods are pretty much under the assumption of a comparative advantage. And the notion that was predominant until the COVID-19 pandemic came was that global supply chain was something positive. So basically, trade is a win-win solution. Trade has no bad thing or bad strings attached. Okay. So in the COVID-19 pandemic, everything changed. And I think it's important to acknowledge that. And the medicine shortages have continued even after the COVID-19 for different reasons. And to give you a number, in the United Kingdom, a developed country, only in 2023, it faced 137 shortages of medicines. So it's becoming really an important topic, not only for developing countries or LDCs that lack manufacturing capacity, but also for developed countries as well. So in my paper, I start basically starting with that notion of global supply chains and how global supply chains are being transformed. Because basically what we are hearing and part of the language of today is this notion of friendshoring, reshoring, bringing back. And that notion I connected to the topic of industrial policy. As you know, WTO law is becoming a tool for industrial policy, and that is part of the conversation right now. How WTO members can use those instruments to enforce and to create an industrial base at home. And in the case of pharmaceuticals, I think it's very important to see the trajectory. And I think Pramiti is going to touch on something very important later on the issue of subsidies. But something that I think is a very interesting, because Yoshi is talking about how the tobacco plain packaging case. And from there, I think we have to take into account the following things that have changed just in a matter of months. First is the adoption of the international health regulations last year by WHO. So WHO has received a mandate from members to expand the manufacturing capacity and the diversification of supply chains. That's for WHO. The WTO has also received a new mandate in 2022. The pandemic declaration says that members have to work as part of the lessons learned to expand the manufacturing capacity. Now, that language, expanding manufacturing capacity and local production, you feel the tension there, because in the trade circles, the notion of trade has a very bad connotation. If you go to a trade lawyer and you ask them about local, the most common response will be to say, to represent or to convey some exceptions, or to say, the local have a bad connotation because it's associated with local content, with certain measures that are perhaps not WTO compatible. What I'm talking here about local production is not really this local content, but basically about expanding manufacturing capacity. And in my view, the topic has profoundly changed as a result of the pandemic agreement. As you know, the WHO Health Assembly adopted the pandemic treaty. Now, the pandemic treaty has an Article 10, which is devoted to local production. So it is a whole provision that members have assumed on fostering local production. There's also an article on technology transfer, which is also very important on that. The pandemic treaty hasn't been entering into force, they have to negotiate an annex, and after they negotiate the annex, if they manage to agree on that, it will be open for ratification, and they need 60 countries to ratify. And once that happens, the treaty will enter into force. So to me, that notion, those events have profoundly changed the topic of local production. And also, there is a political message, very strong, happening right now. And that is the African Union has decided that by 2040, they want to produce 60% of their vaccines locally. Right now, Africa doesn't even produce 1%. So you see the whole transformation from a continent from 1% to 40%, 60%. So that change will be have to happen through industrial policy. So that reevaluation of the dependency of the global supply chain is something that I tackle in the paper. And I think that nowadays government face what I call a very false dilemma, because before all this question, protectionism was always seen as, there is the liberalization, protectionism. I think that dichotomy is really changing. And of course, now this dilemma between efficiency and resilience, governments need to tackle that issue. In the paper, I go into analyzing some legal instruments. I deliberately, I have to confess, run away from subsidies and run away from tariff, because in my sense, they are really the same side of the coin. The tariff are really the consumers who are going to pay the final costs, and the subsidies are really the taxpayers who are going to pay for that. And guess what? That's the same person. So I'm just trying to think a little bit creatively of how the WTO law can be used. And I went in favor of Article 20 of the GATT with letter G. We can later discuss a little bit the implication of that. Because as some of you really know better than me, the panel already, the WTO dispute settlement, has already tackled the issue of local production in some ways. I think in my view, and I already advanced in my position, the position of the panel, I don't think it can be translated in a new case, because I think the reality in terms of the legal commitments is really changing from the reality that case had. If that case were to happen not only in a couple of years, but even today, I will find it much easier to argue in favor of local production than it was when it happened, right? We will see about that. I mean, I'm not going to go into, because I don't have time, but for the interest of time, but I don't have time to go into the legal weeds of all that. For me, one of the really untouched tools or untapped measures is the GPA. So as you know, the WTO has a government procurement agreement, and as part of the negotiation, you can discuss and you can obtain offsets for developing countries as part of the transition. The GPA, I'm very much aware that some countries have not joined the GPA because they see it as a tool that will limit their choices to promote local production. But now the debate is changing, and I'm thinking for two reasons. First, we see that in many developed countries, the GPA is developed as the golden standard to access markets. Recently, the European Court of Justice delivered a very interesting ruling in which it based that if the country was not member of GPA, it could not benefit the EU's advantages or the EU procurement system. So we see how the GPA has become important. And also, I was thinking that government procurement is critical for the predictability. In order to create a local production, you need to create policy measures that will give industry certain predictability in the purchases and also will create some market for the companies to develop that. So that is another solution on top of pool procurement mechanism, which still are regional and limited. The example that I offer is PAHO in Latin America. The EU has one. Gavi is working very intensively in African countries to develop one. So those are some measures. Another measure that I address is basically the notion of Article 31 bis of the TRIPS agreement. And that is an option that it can be explored in case there is intellectual property or there is a patent involved. We will see how the TRIPS agreement and part of the pandemic discussions at the WTO were pretty much involved in intellectual property issues and not so much about goods. Maybe in the discussion we can elaborate. To me, 31 bis is an interesting case because it gives an option to LDC members to develop a more creative formula. It is true, and Pramiti touches with the issue of Bangladesh, very interesting country because it has a lot of local production and how that could play around. We could maybe discuss. So basically, the idea that I wanted to finalize. Well, this is my contact details in case I don't have a very fancy car. I should have brought a very good car. I will do it for the next time. I put mine, so you have my contact details, WhatsApp and email in case you want to shoot me an email. Basically, the idea that I want to leave you with is that the WTO core value is not really liberalization, but regulation. It's giving rules to trade, and that is far more important than liberalization. And in my opinion, I think we have to start seeing trade not really as a consequence of production, but really as a precondition to production. And for that, it is true, I'm not going to deny, government officials have a very heavy lifting task ahead because they have to figure out and tailor their public policy around it, and what it might work from one country, it might not work for the next one. So that is a challenge, but definitely I hope that in the discussions that we are going to have in the future years, because the pandemic agreement will hopefully enter into force if everything goes well. And even if the pandemic agreement enters into force, that will require a lot of implementation. And that implementation will involve procurement, will involve trade, will involve intellectual property, among others. So this is a little bit in a nutshell what I wanted to convey. Happy to discuss this further, but let's try to agree on a positive note that we should not choose between global and local. Let's try to build together a system that it can help us to be prepared for the future pandemic, because at the end of the day, it is just it's a matter of time. So that we will have to face another pandemic, and that the lessons learned from the COVID-19 can be implemented. So thank you for your attention.
Good afternoon, everyone. Thank you for being here. Thank you to all of the organizers, the volunteers for organizing this conference so wonderfully. I think it's one of the best, most well-organized conferences I've been to. So I think my presentation carries on really sort of closely from where Francisco left off. It's about vaccines manufacturing capabilities with a specific lens of pandemic preparedness. And I'm looking at the impact that WTO rules have, and I specifically focus on the GATT and the SCM agreement. So perhaps a little bit of background, and I'm trying to look at this one. Thank you. Thank you. So I want to give a little bit of background as to this, the title of my presentation is Vaccine Manufacturing Capabilities, and how did I come to that? So this paper draws on my PhD, which I just submitted last week, and that's about states' capabilities of least developed countries to access pandemic vaccines. And I specifically look at how the European Union and India impact vaccines access in third countries. So in that, I made this new conceptual framework of states' capabilities, which is essentially, it's the genuine and effective opportunity of a nation shaped by internal factors, so factors that are happening domestically, but also external factors. And the idea there is very much that there are, a bunch of external actors like other states, international organizations, global industry like the global pharmaceutical companies here, etc., which often act through the international legal landscape. And so those are sort of the external factors that I look at. And in this case, in the case of my thesis, and also for this presentation, the idea is very much under the right to health, their states have an obligation to ensure the right to health of their people. But do they have the capability to do so? And I say that that's a very necessary part of the puzzle. So in that sense, I propose that as a complementary framework to human rights, that you can really only meaningfully talk about human rights and fulfilling human rights when a state has the genuine and effective opportunity to do that for its people. To build this capabilities framework, I drew upon third world approaches to international law and the human capabilities approach. I'm not going to go into detail about that, but I published a paper about that in case anyone is interested. Now, the reason why I kind of give this background of states' capabilities is, so in the context of pandemic vaccines access, in my thesis, I came up with 3 different capabilities that a country requires at the minimum to be able to ensure access to pandemic vaccines for its people. And today I'm going to be, and this kind of really draws upon the whole like vaccine development pathway. And so innovative capabilities to make new vaccines or to have new innovation, regulatory capabilities is more about regulatory approval of vaccines, etc. And then manufacturing capabilities, which is what I focus on today. And now that's really grounded in the sort of emphasis on local production. I have the definition of manufacturing capabilities there. But I think there's a bit of sort of background that's maybe important to give here. And I think during COVID, we all saw sort of like the export restrictions that were there, a lot of discussion about intellectual property barriers. We had the 2022 ministerial decision, which in my opinion, didn't really lead to much. At the same time, we also had a lot of people saying, intellectual property is not the issue, it's the lack of production capacity across the world. So there was sort of production and local production, diversifying production of vaccines, medicines, etc., really came to the forefront. And specifically, I think the idea that I'm focused on is another pandemic is inevitable. It's going to happen. That's what all the health experts are saying. And taking that, how do we go forward? How do we prepare for that? And I think the idea that I draw upon here, also drawing upon a lot of WHA resolutions, etc., is that diversifying and strengthening global production. So scaling up global production, but also diversifying that is extremely important. As Francesco mentioned, we have the pandemic agreement, we have the international health regulations, I think both of which are important, but I somehow don't share some of the same optimism that he does. I think these are important instruments. It's great that we have that. It speaks something about political commitment. But I think if you look at the text of these instruments, I'm personally not very happy or optimistic about what that's going to lead to, right? So we have an article on local production in the pandemic agreement, but not the strongest of commitments. Also the same for technology transfer. It's on mutually agreed terms. So for me, it remains to be seen how much of a counterweight they're able to offer to international trade routes. Very briefly, I'm going to mention about so the role of tariffs. So in 2005, there was this report from the World Bank, and the idea also with the pharmaceutical agreement at the WTO, the idea is very much that you don't want tariffs on pharmaceutical products because those are ultimately costs that pass on to the consumers. And why would you want to make medicines more expensive for the people in your country? Which, of course, that has been a prevailing sentiment for a long time, and that has its that of course makes sense. I'm also interested in unpacking that a bit more and seeing if that same idea holds true for all different countries across different levels of development, or if there's kind of a different, not one size fits all, and maybe there's a different strategy that works for countries at different levels of development and different levels of industrial pharmaceutical production capacity. Two other things, I focus a lot on end-to-end production. What that means is to have manufacturing capabilities. It's not sufficient if vaccines are still being produced in, say, the EU or the US, and then like really the final formula is just coming into Africa and being put into the syringes and then sold. That's called fill and finish capacity. In the 1% production that he mentioned that Africa has right now, that's primarily concentrated in fill and finish capacity. But because that's so downstream and end stage, that doesn't really solve the problem of vaccine production, because countries can always put export restrictions at a previous stage. So what you need to have is production capacity for APIs or active pharmaceutical ingredients, and really the ingredients need to be made there. And the second thing that's, I think, very crucial to remember here is this idea of regional capabilities, because I think specifically how, I would say pharmaceutical production in general, but very specifically to vaccines as well, the way it works is that it's just not going to be feasible for every single country to have end-to-end integrated capabilities for vaccine manufacturing in each country. It's an economy of scale, and where that's not met, where you don't have enough investments and enough scale to achieve returns on that investment, that's not feasible. So I propose that the idea is regional capabilities, in the sense that it could be at a continental level, at a local, so more than national, but still local to the regional level. And the idea there is that, again, you need to prevent over-reliance or concentration of supply in one center in that region. It needs to be coordinated. You could have sort of different manufacturing stages across different countries within a region. You could have different sort of specialization, either in different vaccine platforms or vaccines for different diseases, etc. So there's ways to take a coordinated approach where a bunch of countries in the same region can sort of come together and develop capabilities at the regional level while preventing over-reliance on one country within that. So from that lens, I looked at the GATT and the SCM and the Turkey Pharmaceuticals product case, of course. I have to say at the outset, please excuse if I make any mistakes. I'm sure there are 3 people here who know this much better than me. But yeah, of course, so there was a localization requirement. Turkey really said that, it's necessary to protect against a risk of supply shortages. And I think their goal as well was that they wanted to have 60% of pharmaceutical production become local. The localization requirement I'll briefly mention was essentially that pharmaceutical companies which were importing medicines into Turkey had to start local production within a specific amount of time. If they don't, then their products would not be reimbursed by the public social security mechanism. So, of course, there was a whole part about Article 3.8a, which I will not get into for the purposes of right now. But the Turkey also tried to justify it under Article 20b and 20d. And I think the panel said that, they held it's not justified under 20b, and then they applied the exact same reasoning to 20d and also sort of kicked that defense out. And it's this Article 20b defense and sort of the justification and the attempt by Turkey and the panel's and arbitrators' refusal of that I found really interesting, because this idea that a long-term risk of pharmaceutical supply shortages was very theoretical, abstract, and hypothetical. I'm also curious, something that Francesco said as well, that I wonder if the case has to be decided now, if it would be decided differently, it would be exactly the same. That's not very good news for health. And it's really this idea of I think they tried to say that, it's an industrial policy objective rather than a genuine public health purpose. And from a lens of manufacturing capabilities, I think that's the most problematic aspect, because public health is not divorced from industrial policy. Industrial policy very much informs how you set up an industry, including a pharmaceutical industry. And as I just demonstrated through, this lens of manufacturing capabilities, that pharmaceutical industry is very much important if you want to ensure access to medicines, or if you want to ensure access to vaccines, pandemic preparedness in the future. You need that industrial policy. Those are not two divorced objectives. And sort of, this concrete evidence of past shortages, what kind of concrete evidence are we really looking for? And what is the threshold that's going to be enough to establish that rational relationship? And my sort of critical opinion was that the panel took a very narrow-minded view and didn't really look at this very narrow view of like what a rational relationship should be. So I think from a lens of manufacturing capabilities, that's not really made out. I think I'm almost running out of time. I'm not sure. I have time. Thank you. I also looked at the SCM agreement. Of course, I think the ones that were most interesting for my analysis were export contingent subsidies and local content requirements. Why these were so important is because in the last part of my paper, I do a case study of 3 countries, India, Bangladesh, and Senegal, to really look at countries across different sort of levels of pharmaceutical production or vaccine production capabilities at the moment. And each of these countries have used, Bangladesh and India have both used export promotion policies, local content requirements in their subsidies, etc. These would be prohibited under Article 3. And that has been a problem for India in the past with the India export-related measures. Now, this case was not specifically about pharmaceuticals. It was about a bunch of economy-wide schemes that India had in place, but some of them had very direct impacts on pharmaceutical industries, including this biotechnology park scheme, which was basically, sort of a zone where all the participating companies were exempt from duties if they could export the entire production. So that's an export contingent subsidy, quite obviously prohibited under Article 3. India's defense was primarily about its developing country status, which the defense didn't pass. And so I kind of looked at the SCM agreement and the GATT and saying that if you look at it from this lens of manufacturing capabilities, which I argue is essential for pandemic preparedness, then that's not being met here. I think a few different things, specifically in the context of these case studies that I look at, is that, of course, Senegal and Bangladesh are both least developed countries, which means specifically under the SCM agreement, they have exemption from certain requirements. Bangladesh is graduating from its LDC status next year, Senegal in 2029. And so that also would be interesting to see where these countries are now no longer enjoying that exemption. But as when you're graduating from that LDC status, doesn't mean that you immediately have pharmaceutical production capacity in your country magically. And I think, I would say that one more thing that I'm sort of interested in looking at is, as I said, this manufacturing capabilities and state capabilities is really a complementary framework to the right to health. And I think I would be interested in making an argument that in order for a country to be able to fulfill its right to health, it needs to be able to do these kind of industrial policy measures from a lens of access to vaccines, also pandemic preparedness. And I think I would be interested in seeing how that could kind of shape an argument. And a final reflection, I think, is that, and I think this is something that we will discuss in more detail later, I think a lot of these issues are also coming from fragmentation of international law and this kind of regime fragmentation where these two systems are not really speaking to each other to the extent that they should be. So you have the pandemic agreement, you have the WTO, you have the WHO, but like they're not, I don't think that they're speaking to each other in a way that's sufficient enough. And I think that's also what I kind of want to explore with the right to health approach, really saying that that is necessary to ensure access to medicines and moving away from this really short-term focus to a more long-term industrial policy, inclusive focus where if you want to be prepared for pandemics, you need to be able to have those industrial policies in place, which at the moment WTO rules don't adequately allow for. Thank you. I look forward to the comments.
Thank you very much to all the speakers. Thank you for your presentations. I think they were excellent, and I took a lot of notes, so I have a lot of questions. I suggest that I kick out the discussion with a few questions, but then obviously, especially since we're in such a cozy crowd, I would say it would be interesting to also hear your thoughts and questions, and then we can have a open and interactive discussion. I think I will start with Yoshi, and I have to say it was very interesting, the topic you chose. And actually, shortly after you shared your article, there was an article in The Guardian precisely about the Irish measures and the approach of UK government, considering perhaps something similar, or I think some people arguing that similar measures should be adopted. And I was shocked reading about the link between alcohol and cancer, because I was one of those people that we're hearing, especially from my French colleagues, that having a glass of wine is actually very good for your health. So I think it's an interesting, it's interesting, scary, important to realize this link and importance of this kind of measures. But maybe two questions for you. I think one, given this shift that you talk about in terms of acceptance of this kind of trade restrictive labeling, do you think that more countries will adopt similar measures? Because I understand now it's Ireland. I think there Korea, perhaps. I saw that there are very few countries that have health labeling related to alcohol. I mean, obviously for tobacco, it's quite different. So that is the first question in terms of, the trends we can see. And then the second question would be, in terms of any possible future litigation, if you think that future panels, in case someone brings a case either against Ireland or similar measures adopted with respect to other products, and here we can think about highly processed food, sugary snacks, sugary drinks. I think WHO also has, increasing number of reports in terms of health risks of this kind of products. So imagining that there would be specific labeling similar to what happened with tobacco, what now happens with alcohol, do you think that panels would adopt the same approach? Or perhaps, given that we have one case, we also have apple body in plain packaging, but do you think that this is the same approach, the health paradox would be upheld, or do you think that perhaps the approach of future panels would be different?
Thank you, Joanna, for your wonderful two questions. Regarding let me start from the first question, whether in the future, after Ireland, will there be other countries adopting the similar cancer warning labels on alcohol in the future? Well, we still have 30 minutes to go, right? So let me explain a little bit the powerful impact of the panel decision in this case. It's a little bit complicated to explain this paradox, but it is quite simple. We have to draw a line between the measures to reduce harmful consumption, such as tobacco or alcohol, and other health-related measures. So when it comes to the consumption reduction measures, there's always a paradox. For example, the many countries says that, for example, against Ireland, saying that why don't you adopt the education campaigns? For example, that is government is supposed to provide the public announcement to the people, or they use the advertisement telling people the risk of the cancer. They said that why don't you go for that way? But the point is that according to the panel decision. Yes, if that alternative measure, in this case, the education campaign is less trade restrictive, which means that in your country, more imported tobacco or alcohol products will be around, because this is less trade restrictive means that more imports will be achieved within your country, which is completely against the objective of the measure, which is to reduce the consumption. So there's a dilemma over here. Once you pursue the less trade restrictive measures, and at the same time, you cannot achieve the original objective of the measure to the same extent. So this is the dilemma. So this dilemma was clearly accepted by the panel, which means that this is a very big driving force for other WTO members to go for the measure without being worried about the future challenges provided by the other members, as WTO members gave up with respect to the Ireland measures. They just stopped raising the concerns because they think that they have no other choice. They cannot successfully win the case, in my observation. That is created by this panel decision in the Australian plain packaging, in my view. So therefore, the answer for the question for the answer for the first question is definitely yes. There will be more countries, like as you said, tobacco. There are almost 100 or I think close to 200 countries in the world which now adopted regarding the tobacco health warnings labels on tobacco packages, except Japan, for example. So that is going to happen for sure. But to the second question, what happens to the future dispute? My point is quite clear. In the WTO Australian plain packaging case, the panel didn't have to mention this paradox because outcome was kind of obvious. The complaining parties proposed 4 alternative measures, including education campaigns, instead of the plain packaging the measures. Nevertheless, the panel concluded that, look, for example, based on the specific evidence, they said that those alternatives cannot reduce smoking as effectively as the plain packages. Sorry, we don't have enough evidence to support it. The panel could have simply said that instead of referring this complicated paradox when it comes to the consumption reduction measures, or you cannot, we have this kind of paradox. They don't have to mention that. Nevertheless, they still did it. So what is the message behind the panel? In my view, they want to send us a message like, yes, in the future, if you want to pursue the measures trying to reduce harmful consumption, such as tobacco or cigarettes, go ahead. We help you by referring to this paradox, which is very hard to rebut. So that is my observation. So based on this panel decision or panel's intention, I think that this panel thinks that this similar approach should be taken in the future by the future panels to help countries go for that direction. So that is the answer for your question. Thank you.
Thank you very much. I think let's move to the issue of local production when there are a lot of different elements and aspects. And maybe one question to start, and then I would be curious also to hear Pinar questions and comments. We see now, and you mentioned as well, that the idea that local production is something that can actually help with access to medicines, to vaccines, is shared by many organizations, WHO certainly, but also WTO to a certain extent. So there is, general understanding and support for that idea. The question is how to achieve it. So what I would be interested to hear from both you, Pramiti, and Francisco, what do you think would be the most effective measures that could be taken, also taking into account the WTO consistency of such measures? So you, Francisco, you mentioned that local production, it's more about manufacturing capacity. And I would tend to agree with that. My question is how to achieve that. What would be the specific measures that can help you have this local manufacturing capacity without violating WTO law?
Thank you. Thank you for the question. I mean, that is for a PhD work, and I don't claim to have the answer. What I think is there's something that has changed, and there is one, the political sensitivity, and second, the legal commitment that it is there, still to be, it's a nasciturus, still to be born, but it will be a legal commitment, presumably. So to answer your question, what could be the effective measures? So to me, and I come from TRIPS perspective, so I don't come from goods, and I always have criticized a lot the Article 20 because it's always a slippery road. You have to start by presuming that the measure is inconsistent, unlike with Article 8 of the TRIPS agreement, that you have to start that the measure is consistent with the agreement. So the logic really changes. So to address that, I think coming from TRIPS and coming from intellectual property, for me, expanding manufacturing capacity encompass a lot of different policy choices. First of all, I think, Joanna, there is a great need for countries to figure out what are the supply chains in their countries, mapping out manufacturing capacities. If you ask many countries, they don't know what is produced in their countries, what levels, what they trade. Part of it is because customs authorities have difficulties in identifying trade flows of medical goods, because, as you know, the harmonized system, it is not very good, and they are still in the process of amending the harmonized system. And actually, customs authorities have struggled quite a lot to let you know how many vaccines one country is purchasing or it is producing, because customs data is not available. So I think two things. First, you have to do the homework of identifying manufacturing capacities, identifying the supply chains of the companies that you have in your country. Third, you have to identify which goods you want to produce. I think we have to be honest. I was, when Pramiti said, oh, the pandemic agreement, they don't have technology transfer, all that. It is sort of like, if I come to you and say, I want to be married to Monica Bellucci, because I fancy her, it's like, well, yes, I can wish to be married with her, but I don't even have her telephone number. So this is the same. Countries have to focus on what can I reasonably propose or achieve. And why I'm saying this, for example, in France, part of the discussion is to expand manufacturing capacities of antibiotics, which are of patent. So therefore, the IP element is out of the equation. You know what I think? If, for example, my country wants to push for vaccines, it depends which disease. Because, for example, yellow fever vaccine, it is from the 50s, it's already off patent. However, if I want to start producing mRNA vaccine, I'm going to need a lot of patents, because that technology is still pretty much patent protected. So I think countries have to make the choice first, after doing all this analysis, is to identify which goods. So vaccine, okay, but what kind of vaccine? Therapeutics, okay, but what kind of therapeutics? And then try to identify measures that can help to tackle those. So I give you already an example. If I want mRNA technology of vaccines, I really need to develop an ecosystem. If it is not, because it is off patent, then I can focus on other policy choices, on other measures. Procurement, I can see whether, Pramiti has mentioned the subsidies, the tariff. Tariff is interesting because in the pandemic, many developing countries still today have very high tariff on medical goods. For example, diagnostics, very high. Masks in many countries have 45% of tariff. So, for example, if I want to push my country to develop diagnostics, then I need to also tackle the tariff question. So it will depend really on the goods. And it will also depend on, after having done the supply chains and mapping out the manufacturing, so all those processes, then we can start doing the homework. I'm not saying it's easy. Sorry, I hope my question is too long. So I hope it, more or less I tackle your very, very interesting question, very difficult to be brief. So I hope it's okay.
Thank you. I agree with you. I think it's a very interesting conversation. So I think I'm also going to struggle a bit to keep my thoughts in order. But please, apologies in advance if I'm rambling a bit. But I would say, I think with any of these kind of things, it's always about having a bunch of different kind of tools in your arsenal and using a combination of them together with the understanding that not all tools are going to work equally well for everyone. I think also that the paradox that we mentioned earlier in the context of alcohol labeling might also be true here, in that the most effective measures might be the most trade restrictive. And so I think that's a little bit of a troublesome thing. Measures that I would say, I would start from like the least restrictive would be something like general investments in infrastructure in the country, across the industry, and just general investments by the government without specific focus on local content requirements or export promotion subsidies. Those would be, I would say, the least restrictive, but again, a very high burden for governments to undertake, or where donors are able to step in. That's maybe a burden that can be outsourced, but we've seen a lot of issues with donor-led initiatives. I think another initiative, which is very interesting, but has run into problems because of political commitment and other issues, is the WHO mRNA Technology Transfer Hub. So you have a hub, which I think for COVID was Afrigen, a South African company. They started making their own COVID vaccine. First, Moderna said that they would not, like Moderna waived off its patent on its COVID vaccine, but then no one was willing to share the technology with Afrigen. So they started reverse engineering and making their own vaccine. That, of course, takes years and years. And by that time, COVID was essentially not really a thing. The demand for COVID vaccines had already gone. So I think that shows the kind of problems that are there with these international initiatives. At the same time, I also have, so now the WHO mRNA Technology Transfer Hub, which started with a focus on COVID, has shifted more broadly to different diseases and mRNA technology platforms that can be utilized across different diseases. So I think tools like that, again, with multilateral cooperation, are a very good idea to generally boost local production in different countries, and I would assume are less trade restrictive and therefore more compliant with WTO rules. Having said that, I don't think that those are enough. And I think that, as I said, that paradox holds very much true. I think we do have some interesting avenues within the WTO regime. You already mentioned Article 20J, which I think is an interesting one. I think Article 21 can be very interesting, especially when you look at pandemic preparedness. And there's been an increasing amount of health securitization and essentially health and pandemic preparedness as an issue of national security. And I think that gets into a very interesting area because, as we saw with Article 21, states have a lot more discretion. So I think that could be an interesting argument. I don't know how that would be received, but I hope that comes to a case soon. And that would be very interesting to see. Another thing would be with now, say, with the pandemic agreement, I would also be interested to see if at any points in the future, WTO panels or the disputes that the arbitration, or hopefully at some point the appellate body, would be referring to the pandemic agreement as a kind of justification or as in support of local production and industrial policies, similar to how, say, the FCTC was used in the tobacco case. I think there's key differences between the FCTC and the pandemic agreement. The FCTC has a lot more guidelines and is a lot more operationalized and instrumentalized. The pandemic agreement at this point does not have that. But at the same time, it does represent an important political commitment. And I think if a dispute settlement body has that will to kind of go into that direction, that could be an interesting justification or support for these kind of local production measures. And then I think the last thing that would be a bit tricky is especially when we start talking about regional capabilities and regional coordination. So I will give an example where Senegal, in its pooled procurement, in its medicines procurement, it saves certain medicines for national tenders only. So only domestic producers can even apply for those to supply those medicines. Now, the issue is that because Senegal is a part of a monetary union, which is the West African Economic and Monetary Union, WAEMO, that national preference is also extended to all regional producers within that region. Now, in this case, where it's an economic union, it could be justified under Article 24 GATT. And especially, I would say that in a lot more cases where it's not such an economic union, but more loosely regional integration, and it's going to be even more difficult. And I think Article 24 is never an easy threshold to prove anyway. No. And also to say that of course, only applies to GATT and not to SCM. So I think it's a very complex puzzle. Interesting sort of inroads being made into that. I think there's some areas where there's more teeth than others, and I would be very interested to see if that ever leads to some kind of a judgment. Yeah.
Thank you very much. I would say let's open the floor to other questions and comments. So I don't know if you, Pinar or Ur, if you would like to share some thoughts, especially on the famous Turkey pharmaceutical case, but in general on what we discussed, please.
It works. Thank you very much, first to Joanna, but then all of the panelists. It's been really a true pleasure and honor to listen to all of you, because both Ur and I, we come from Turkey, and that case, the Turkey EU Pharmaceuticals case, is very dear to our heart. And my heart, I don't know about Ur, probably he'll say the same thing, my heart is still aching for what happened in that case. But as a black letter WTO lawyer, I can also understand why this case had been decided in that manner. This said, I'll come back to the Turkish EU pharmaceutical case, but I have a couple of questions to each of the speakers. I very much enjoyed the alcohol matter, which we were expecting, and I'm never tired to say to my students every year that we should by now have lots of countries which are bringing alcohol-related warnings on bottles, very similar to tobacco plain packaging. And I was so happy to see your presentation. I think it adds a lot of things to the entire international trade regulation. But I was wondering, when you were making your presentation, the fact that you were comparing the Thailand case and Ireland case, why there is that much difference in the reaction which is shown to Thailand and Ireland. I would be interested in knowing a little bit more about the specific trade concerns, what exactly in the TBT committee, the way they approach the Thailand measure versus Ireland measure. And I'm also interested in seeing, after the tobacco plain packaging case, many countries had a regulatory chill when they were trying to bring some regulations. I was wondering whether you would find the same regulatory chill in investment agreements, for instance. It may not be your immediate working area, but if there would be such a decision by the WTO panel related to alcohol warnings on the bottle, perhaps the countries do not want to have any panel precedents. That's why this regulatory chill makes them stay far away from the panel decision in the Australia tobacco plain packaging, because that would bring a precedent, and that's why probably they don't want to challenge the Irish measure for the time being. So I would very much recommend you look at the regulatory chill aspect of it. That would be my 2 cents. Francisco, I very much liked the presentation. Honestly, when I looked at the program, I didn't think that it would come to this point. TRIPS relevance and the local production. I know you said your usual disclaimer saying that you're not representing the WTO, but I was very much pleased that with an open-minded and very, innovative way of looking at things, I very much hope that this will happen. But I was also interested in asking to you, you said the GPA could be an answer. Joanna, I, and Ur, we all know very well why in, Article 3.8, government procurement defense, unfortunately, did not work at all in the Turkish case. Now, if Article 3.8 did not work, Turkey, which is not a member of the GPA, do you think things might have worked differently for Turkey if we were a member of the GPA, even though, we could not really, already make the case for procurement under the 3.8? So I would be, very interested in hearing about you. Pramiti, congratulations on your defense. I think it's very well worked. I wish I could be at your defense. You submitted. Well, you were going to pass with flying colors, that for sure. It was super interesting. And what I wanted to know, actually, a little bit about the technology transfer aspect, because that was a huge problem in the Turkish case as well. Luckily, we did not have a forced technology transfer provision in the Turkish legislation. That would be even worse had we had that. So if you can clarify how you see strengthening the position of LDCs in local production, by basing yourself in the pandemic, etc. But this technology transfer issue is very important. Now, in the Turkish case, when we all were looking at the matter, many EU companies were actually happy to come and get localized in Turkey, like Novartis. Novartis said, we don't mind localization requirement by the Turkish government because we don't have a compulsory technology transfer. Actually, we're not bringing the entire production back there. We're just using the API and we're just, making the package. So there's not big problem for us. So how do you think this technology transfer issue could be implemented in this? And last but not least, I will talk about this on Friday in our own session. The way in which I look at this case, Joanna and the team, they try to do their best, as a law firm. But I think it was a missed opportunity, the Turkish-EU pharmaceutical dispute. Now, you were saying, could it be different if it had happened after the COVID-19 pandemic? I honestly think it might not be, because the interpretation of Article 3, national treatment principle, and of course, Article 20, has to be looked at from a different perspective. Now, I look at this problem, localization and local production, and I, kindly invite all of you not to just focus on the pharmaceuticals. Today, in the geopolitical world we live in, everybody is trying to get the production on site. Now, if you try to approach a case against the United States for calling Tesla to produce in United States, or European Union inviting all of the foreign companies to come and produce in Europe, that's the localization requirement in disguise. So how do we approach all that under the new national treatment principle? Creating national champions, everybody is doing it right now. So that's why my idea is we need to find a new interpretation to national treatment principle. What is the like product? How do we, create that Article 20, of course, chapeau, then 3? That is, I would be very glad, if you can also think about it in that perspective. Do you want to say something, Laura? Of course.
Well, I'm not only given the microphone, but also the mission impossible to complement Professor Pınar's questions. No, actually, just a few, just to compliment you. I'm also super curious to get to know a little bit more, because I'm not familiar with the cases, the design of the two measures, and what are the differences, because if indeed we're talking about the two measures in Thailand and Ireland, then indeed there must be a shielding effect or something. But yeah, perhaps you can focus on more like the design, like what are the differences, that would be very interesting to know also in the paper. And for the localization, what I'm curious about is that in the case that we were working on, indeed, one of the biggest problems was the technology transfer. But at the same time, we were all like thinking about like what would be the best system that would be, Article 20 proof, right? Based on your researches, I would also be interested to know whether, reading about the case and all the facts and details, you thought about an alternative that could have flight much better for everyone to know for the future. Yeah.
Perhaps I can add something to both of you. One point which was missing, and I'm sure Joanna can confirm us, is that the Turkish government had taken this localization measure in order to ensure independence towards the foreign medical pharmaceutical companies. But in the governmental programs for the 10 years or 5 years development plans, they never mentioned that. So it was one of our biggest points. So if a country is truly sincere in saying that we're a developing country, as a developing country, this is within our development program for the next 5-10 years. So we're going to ensure that we can provide affordable medicine to our people. The Turkish government has never done it. So one way of making your case WTO compatible is to be sincere in the way you are writing down these laws. And often, government officials, when they are writing laws, they are not aware of the WTO commitments. But this is one of the ways in which perhaps we can approach. Thank you.
There are a lot of things to take on, but I suggest that each of you, and then if we have time I can make some comments as well, try to address all these questions and issues. I feel yeah, so I don't know who wants to start.
Thank you, both of you, for the very insightful the comments, especially regarding the difference between Thailand and Ireland. Let me mention only one thing because time is limited. When I look at the minutes of the TBT committee closely, the biggest difference between Thailand and Ireland is actually the science. And for the Thailand's case, many WTO members kept on saying that what is the science? What is the scientific basis behind these warnings? Especially many of them refer to the moderate drinking, actually. But which is now actually, that is not the case. When I looked at the TBT minutes of the Ireland, there's only one or two members referring to the scientific basis concerns. So I think I didn't have enough time to dig into this issue, but science also seems to be playing a very important role to distinguish these two cases. So, but thanks, I will try to look at as well at this point, as well as the regulatory chair. This is another suggestion from you. So thank you very much for your insightful comments.
Okay, maybe I can tackle all the questions, some of them. Yes, just to reaffirm, this is all my personal views, right? So I do not represent the Secretariat. The GPA for me, I was trying to be creative in how members can do this. So why I said that this case will be solved differently is because every new case, every new panel is a new battle. There is no precedent. I know this is something controversial for some, but from where I stand, every new case is a new beginning. So we do not know if a similar case will happen, how it will be decided. That being said, I have to share that it was a difficult case to argue from the beginning. I don't know what Joanna thinks, but usually lawyers, we are always called when there's litigation, not in the first step, right? Because I think lawyers need to also be asked in the beginning. I think at some point, if I have received this case, I will try to have settled with the EU before going to litigation, because there was a case of, very clear discrimination. So it was difficult. It was a challenging case to defend. It was very difficult. I have to argue, for example, maybe I don't want to disclose, but for example, the argument of the currency, at some point it was floated there, the currency issue. I saw that very potential. I like the idea of that. Unfortunately, there was not that much development on that side. But going back to the GPA and to focus your question, I think the GPA can have a huge potential. Why? Well, first, the GPA is a golden standard to access other procurement markets. The European Union has received now, with the China case, with the International Procurement Instrument, has already launched an investigation against Chinese authorities. Sanctions are underway for discriminating in procurement system. If you are a member of the GPA, you can access the European market without this on equal footing. We have to, and then the other aspect I think is critical is for the GPA, it is it's a very tailor-made accession process. So you liberalize after a certain threshold that you want for the agencies that you want, provided that you get the agreement of anybody else. And then if you're a developing country, you can get offsets. So conditions, for example, I would require that you hire local workers, or I would require technology transfer. So to go to your question on technology transfer, if you are part of the GPA, you can liberalize certain sectors while imposing offsets. So basically local working conditions, right? Israel has done that. Chinese Taipei has done that. So it's something that has already been done. You have to be very creative because it's something that you have to put numbers because you liberalize after a certain threshold. So contracts above a certain level then get open to GPA parties and others below no. So it's a very good exercise for countries to say, I want to liberalize my market up to a certain point and not too much, and then also giving certain leeway. And to your question on technology transfer, I think the GPA could be an instrument, although it's more related an IP. To the technology transfer, I think the forced technology transfer, although it is true there has been, to my recollection, 2 cases. One, the EU with China on technology transfer, which is still in the air, and then the failed one, the US China case on that. But I think the TRIPS agreement is very clear that the whole purpose of IP protection is technology transfer, and you could try to have done some additional reasoning. I think that Article 20 is always a very bad way to go because because you have to admit that already from the outset the measure is not compatible, and then of course in this case it was criticized by the order, no, how the panel tackled the question, the chapeau or not the chapeau later. So it's a difficult reasoning. The European Union in the pandemic proposed to have authoritative interpretation of Article 20. Nobody listened to, and there was no interest of moving things. So.
Thank you for the question. I think the technology transfer one is really interesting, and I would say, of course, technology transfer is a crucial aspect of this whole idea of like local production and increasing manufacturing capabilities. But it also matters what kind of technology transfer it is. And I think not all technology transfer is equal. And so, for example, like the example that you gave of Novartis, we see this with a bunch of big pharma companies that when it comes to downstream production or really just fill and finish activities, that they take their formulas there and just put it in the syringe, they don't mind that because that's essentially just the last step of the supply chain, and you don't need to share a lot of your innovative technology. And it's really the innovative technology that threatens to create more competition. And that's why pharma companies, of course, don't want to do that. But I think the idea, and also with this focus of end-to-end manufacturing capabilities, is that in the long term, that's really not sufficient if you want to have sustainable manufacturing in your country or in your region. You need to be able to produce from the very beginning, and you need to be producing the ingredients, and just that fill and finish is not going to get you there. In my thesis, I sort of draw upon science and technology studies and more industrial innovation studies to essentially the concept of it goes beyond technology transfer, and what's really needed is knowledge diffusion, where the people in these countries get that tacit knowledge about how they can start producing these vaccines from scratch. So in that sense, I would say that not all technology transfer is equal, and pharma companies will always try to find the sort of sneaky way out. And I think then, of course, compulsory technology transfer becomes very interesting. And if the pandemic agreement negotiations had gone differently, and we didn't have that qualifier of, the technology transfer will be on mutually agreed terms, then I think we could be having a different discussion where if you have one international instrument saying that technology transfer, even on mandatory terms, is necessary for pandemic preparedness, then I think that would be very interesting, because then it would become about conflict of norms. But of course, we didn't get to that. And I think in that, it's also very interesting, something that you said in your previous answer was that the Monica example. And of course, countries can want some things, and political commitment, especially along global north and global south lines, is always very different, and we don't have that. And I think in that, it's very important to keep criticizing and to keep sort of not accepting the standard that has been laid down. Because the minute you start doing that, is that you risk creating new normative acceptance that voluntary technology transfer is the way to go, and that's sufficient, and then we can all give ourselves a pat on the back. And it's necessary to not do that. So I think criticism has a very important role to play in that. And I would say, I mean, I understand like the Turkey Pharmaceuticals case, right? Of course, your heart aches, and of course, there's merit to negotiations and settling outside in that case. I will, now that that's behind us, I will take a more optimistic stance and say that, you have that in public record, so there's potential for criticism, and with that, hopefully at some point comes the potential for reform. I think that's a very optimistic take, but I would like to end on an optimistic note. And then the last thing, in response to your question, I think Article 21, as I said, would be good, but really only with the lens of pandemic preparedness. I don't see that flying with other kinds of medicines if you can't really link that to health security. And I think that more work needs to be done there for like making health security as national security, that link more explicit. But I think there is really some potential there. And I think also your point about, that Turkey had not mentioned these things in its policies or its development plans in the previous years. That's very interesting. And I fully agree with that. And I think as lawyers, we often I at least often tend to dismiss those kind of soft law policies. So I'm just like, oh, they're just soft law norms and principles. No one cares. Yes. Yeah. So I think that's a very interesting thing to keep in mind. Yeah. I think that also ties. Yeah.
I think we are completely beyond the time. So I would say I would like to thank everyone in the room, especially the speakers, for their excellent presentations, for a great discussion. And I suggest to continue the discussion. I think there are drinks outside. So we have time for more questions. Okay, I'm sure there are non-alcoholic drinks. Or at least the labeling is not there yet, so we can all pretend that moderate alcohol consumption is okay for just for a few more days. So thank you very much, and let's continue outside.